Ms. Chia Yong Yong.
Mr. Deputy Speaker, I declare my interest as a lawyer in private practice. I join my colleagues in this Honourable House in support of the motion and echo the proposition to recognize that seniors are a gift to us. Indeed, seniors should be respected, even if they cannot contribute anymore. Sir, the social compact in Singapore is evolving. The success, stability, and economic benefits enjoyed by us today have been built upon the sacrifices, sweat, and tears of our seniors. They suffered loss that we might gain. As a country, we owe it to our seniors to enjoy their golden years in dignity. More fundamentally, as individuals, we owe it to our parents to enjoy their golden years in dignity. Regrettably, it appears there are some among us who don't agree with that statement. We have all seen many, too many, cases of neglect, abuse of seniors by their adult or even middle-aged children. Yes, there could be bad blood between a senior and his or her children. Notwithstanding that, few among us will condone neglect or abuse of such seniors by their adult children. Accordingly, Mr. Speaker, Deputy Speaker, whilst I firmly believe that filial piety cannot be legislated, I submit that Singapore needs a more robust and coordinated framework towards ensuring that our seniors will be well taken care of. The Honourable Member, Mr. Henry Kwek, proposed 3 policy changes. I propose 3 complementary actions: education, bolder use of existing legislation, namely the Maintenance of Parents Act, or MPA, and supplementary legislation. Firstly, education. Caring for a person is not about how lovable a person is, or how fragrant the person is, or how affordable or convenient it is to care for that person. Particularly in the context of a parent and child, it is about love and obligation. And obligation, even if there is no love. As a community, therefore, we must continue to emphasize the value of filial piety. It should be taught at home. Parents should set the example, and it should be taught in schools and religious institutions. We should also recognize that with or without filial piety, financial dependence on children can strain and has frequently strained parent-child relationships. So let us empower seniors to take control of their financial assets in order to reduce financial dependence on their children. Whilst it is understandable that seniors would like to give properties to their children, the gifts can be made after they passed on. In principle, they can reduce their financial dependence on the children and still leave legacies to them using 2 legal instruments, the reverse mortgage and the will. First, the reverse mortgage. We should intensify and expand our ground efforts to inform seniors of the advantages of the reverse mortgage to HDB and other financial institutions, and encourage a higher take-up rate. The payouts from the reverse mortgage will enable seniors to reduce their dependence on public assistance or the children. The remaining value of the flat or property can still be gifted to their children after they have passed on. Second, the will. We should encourage seniors to maintain themselves out of their own properties. They should not make gifts to their children in their lifetime. By making a will, the senior can continue to own and enjoy his or her property and leave the remainder after they have passed on to their children. A will can be changed at any time by the senior. This means that an unfilial child can be written out of the will at any time. By using the will, the senior retains, to a large extent, the control over his or her assets and finances and financial independence. Of course, some children may not be happy to wait so long. If the parent-child relationship deteriorates because the parent had decided to take control of his or her own finances, then all the more the parent would have made the correct decision. Deputy Speaker in Mandarin. 一般的父母以给的方式表达对儿女的疼爱，因此许多年长者便将自己的财物 给或者转让给儿女，之后才体会儿女的不孝，被他们虐待、忽略，甚至遗弃，就是没有那么嫉妒。父母儿女关系也常因钱财问题恶化。为了减少冲突，我们应该呼吁年长者尽量减轻对于儿女在经济上的依赖。在有生之年，千万别把财物给儿女，放着自己用，以遗嘱分配剩余的遗产。年长者可以将祖屋反向的抵押给政府建屋局，不但不用分期付款，相反的，每个月有收入，以遗嘱分配剩余的遗产。遗嘱还有另外的一个好处，就是随时可以修改。有孝心的儿女可以受益多一点，不孝的受益少一点，或者一分也不给。如果您的儿女因此的安排而不满，那就证明老人家所决定的是正确的。Deputy Speaker, secondly, I would like to propose a bolder use of existing legislation, namely the MPA. The MPA empowers the Commissioner to make applications on behalf of seniors or parents and represent them in proceedings or appeals under the Act. This is an important power, considering that family relations could be further aggravated when applications are made by parents against their children. Where the Commissioner has sufficient evidence at hand, the Commissioner should make the application, notwithstanding that the parent may not be willing to adduce any evidence against the children. Could the Minister of Family and Social Development confirm the number of such MPA applications by the Commissioner from 2010 to date? When an order for maintenance is made and not complied with, the Act provides a further mechanism in which securities can be made and ordered out of existing property. This is also extremely useful and assists the seniors without having to make another round or commence another round of legal proceedings. Can the Minister also share the number of such orders that have been made out of Section 6 of the MPA? I would also urge the government to make express provision under the MPA to allow attachment orders to be made against salaries of children, which leads me to my third point, supplementary legislation. Whilst we are not in a position to legislate filial piety, and we should not, as Professor Walter Woon pointed out in his speech during the second reading of the Maintenance of Parents Bill in 1994, we can provide a safety net if filial piety fails, and we should. And here, if I may add, that in my view, the Vulnerable Adults Bill, in the form presented to this House at its first reading, is inadequate in that it fails to legislate financial protection for vulnerable adults, including the elderly. I hope to hear more from the Minister on this issue. At this point, allow me to share a couple of stories which I constructed from incidents made known to me. Mr. Tan was a manual worker. He and his wife had 3 children whom they provided for and raised. Before Mr. Tan passed away, he added the name of his eldest son as a joint owner of the flat, expecting that his son would care for his mother, Mr. Tan's wife. After he passes away, Mrs. Tan continues to stay in the flat with her son and family, but is treated as non-existent by the son and family as far as they are concerned. She sleeps in the living room, cooks porridge for herself, whilst her son, daughter-in-law, and grandchildren enjoy sumptuous meals. The other 2 children, meanwhile, are estranged from Mrs. Tan due to the unfairness of the flat having been favored to their eldest brother. The second story. Mr. and Mrs. Lee worked hard to bring up their only daughter. When she was about to be married, they sold their HDB flat, gave the proceeds to their daughter that she might buy her own flat. The understanding was that they would move in to stay with her. things didn't work out as planned, and they are now left homeless. Stories such as the above abound, and we may simply change surnames, number of children, permutations, but the result is the same. Parents part with their properties, their sale proceeds, their savings, only to be left with nothing, not even provision from their children. Many of these parents may not wish to initiate proceedings under the NPA. Many of them may not even be eligible under the NPA. But all of us can see the injustice and the inequity in such situations. The children have taken their parents' property and left them bereft. It is irresponsible, cruel, unthinkable, but it happens, and often too. The law as it now stands is against the parent, and I speak with particular reference to cases where property is transferred or given by a parent to his or her child. The current situation is that parents do not have much of a recourse. We do not understand as laymen when we think that we give a property to our children for them to look after us, we think we can have it back. But the legal position is, once we transfer the property, we cannot take it back, especially if we are a parent transferring the property to a son or a daughter. The law presumes that it is meant as a gift, and this is known as the presumption of advancement. The burden falls on the parent to rebut that presumption. Of course, there are exemptions. There are such as trust, fraud, undue influence, but it's hard to prove. And in each case, the evidentiary burden on parents is extremely high. In addition, adducing evidence may involve other family members and widen the family dispute, which is not at all to be encouraged. The law as it stands also doesn't take into consideration changes in circumstances, such as where a child has a change of heart towards his or her parent after receiving property. So they are left to suffer in silence. But ultimately, someone has to look after them, right? And here is where the state steps in. But that's not right. We can all see the unjustness in this situation. It is not right. And we cannot encourage such reprehensible behavior. So I urge the government to consider reviewing the law to supplement the NPA and to seriously consider the following. First, abolish the presumption of advancement in circumstances where an elderly parent transfers property to an adult son or daughter. The law is anachronistic. We've got to change that now. We are faced with vulnerable seniors, mostly with only one HDB flat, not landed gentry. These are vulnerable people who give their property to their children who then neglect, abuse, or abandon them. Second, we should legislate conditions under which a trust in favor of a parent can arise or must arise by operation of law, such as where an elderly parent transfers a substantial portion of his or her property to an adult son or daughter, so that such son or daughter will hold the property on trust for the parent. Thirdly, we should provide for transfers of property to be voidable at the option of the parent in the event that the child fails to provide basic amenities or basic physical needs to the parent after the transfer. We should legislate to place the evidentiary burden on the receiving party to show that he or she had not defrauded, coerced, or exerted undue influence on his or her parent, that the market consideration had been paid to the parent, and that such money had not been routed back to him or her. We should provide that the statutory obligation to maintain one's parents arises immediately upon the transfer of the property from parent to child by operation of law. Now, this could apply when the transfer cannot be faulted. Sixthly, we can amend our penal laws to provide harsher sanctions against those who prey on the financially vulnerable, of which the seniors should by default form a category. In addition, the government could consider a compulsory savings scheme whereby a part of CPF contributions are channeled into a new sub-account designated for the purchase of annuities for the maintenance of the members' parents. I do note there are areas of overlap and potential conflicts between the above measures that I have suggested. We should not be deterred. we can and we should rationalize and implement the measures holistically to form a robust framework to support seniors and reduce familial strain attributable to money matters. I am also well aware that enforcement will be difficult since we are dealing with family relationships, but we put the cart before the horse if we say enforcement must be achievable before we can set up a framework. Tell that to an elderly person. I will not give you the right to take back your property because you may not be able to take it back anyway. Can we say that to an elderly person? It is as good as a doctor telling his patient, I will not give you any option for a particular treatment unless I am sure it will work 100%. I don't think doctors will say that, and I don't think that we as Parliament should. Excuse me. I need to take a break, so I think it will be. Excuse me. Yes, thank you. My apologies. I do not think that this Parliament, this House should be swayed by any argument that we should not have a framework unless we can ensure enforcement. We need to set our moral and legal principles right, and the rest will follow. I wish to emphasize that I do not advocate that we legislate filial piety, or worse still, replace it. Excuse me. Fundamentally, the responsibility, the privilege, remains with the family. And if I may quote from Professor Walter Woon, in response to any concern that my proposals could be too interventionist, are we being too interventionist?
Do you want straws? Would you like this?
Yeah, I do. Beg your pardon, can I have a sip, please? Thank you.
Slowly. It's okay.
Thank you.
Thank you.
Professor Walter Woon, from his speech during the second reading of the Maintenance of Parents Bill in 1994, said, "The bill is not aimed at the majority of Singaporeans who know their duty, who know where morals point, and who support and love their parents without having to be told. The bill is aimed at that recalcitrant small minority that cannot be counted on to do what is right. And therefore, it will not affect the vast majority of Singaporeans." So, Mr. Speaker, my proposals are aimed at that recalcitrant small minority that cannot be counted on to do what is right. Currently, other Singaporeans have to pay for that failure. It becomes an additional expenditure of public funds, which could have been diverted to support those who are truly without family or for other national purposes. A little leaven leaveneth the whole lump. Not just a matter of public funds expenditure. Such cruel and reprehensible behavior, if left unaddressed, will immunize our people against basic human values. It will immunize our children and set the tone for what our children and society will become. It will immunize us against responsibility, suffering, justice, and equity. What is now unacceptable will soon be common landscape, the way life is. What is now reprehensible becomes our lifestyle, the way we are. The family unit will be threatened. Our social fabric will tear. We have to do something. We have to do it now. We need to set our moral and legal principles right. Otherwise, we fail miserably as a government and a society. Let's do right by our people. On that note, Mr. Deputy Speaker, I support the motion. Thank you.